Welcome to this BB webinar, which has been designed to help you understand and comply with the law around right to work checks. In this session, we'll be setting out what is a right to work check and why you do it, to whom does the right to work check apply and how, the practical steps in making the checks, and in dealing with queries. So, what is a right to work check? Well, it's a legal requirement that you have to comply with around a person's legal status to work in the UK. Upon who does the right to work check have to be carried out? Well, it has to be carried out on all potential employees. Don't just assume because of the way somebody looks or dresses that they have the relevant right to work or they are a certain nationality that you don't have to carry out a right to work check. A right to work check applies to all workers regardless of their nationality. There is a code of practice for employers about how to balance the right to work checks and also ensure that you don't carry out any discriminatory actions. It's important to follow this code, else breach of this may be used against you in potential scenarios where you could be fined. We will be covering this later on in the seminar. There is an ongoing duty to carry out right to work checks, particularly for those who have time-limited rights to work in the UK. It's important therefore that you recognise this and that you do make sure you comply with this ongoing duty. So why do you have to do the right to work check? Well, if you didn't, it would be illegal and the law does require you to do it. As a consequence of not doing a right to work check, you could be fined up to £20,000 per person. More importantly, if you knowingly employ somebody who has no right to work, it is a criminal offence, and that could mean an unlimited fine or possibly up to 2 years imprisonment. So how does right to work check apply? Well, it's essentially a three-step process. The first step being obtain original versions of one or more acceptable documents. The second step being to check the documents in the presence of the holder. And the final step is to copy and make a clear copy and record the date the check was made. Providing you carry out these steps, you will have what is known as a statutory excuse against any potential fine scenario if the individual was later found not to have a right to work. Step 1. Obtain the documents. The documents you obtain must be those set out in either List A or List B. The table of List A documents is shown on this slide. If you are given a List A document when carrying out your check, then you will have what's called a continuous statutory excuse, as the person will have shown they have an indefinite right to work in the UK. You don't need to carry out any further checks after employing this person around the right to work. If somebody doesn't provide you with a List A document, then they must provide you with a List B document to show that they have a right to work in the UK. These are split into two groups. Group 1 documents provide a time-limited statutory excuse, as they will show a person has a right to work for a limited period up until a set date. You must be careful to make sure that you diarise that particular date, but you will have the statutory excuse up until that point in time. Group 2 documents are ones which have a very limited statutory excuse that lasts for just 6 months. So you would need to carry up and do a further follow-up check before that period was ended around the individual's right to work. Step 2. check documents. So you need to check that the photographs you have in the documents do marry up with the person standing in front of you, and that there aren't any abnormalities around that. That there aren't any expired dates in the documents that would make it impossible or difficult for you to employ the individual, particularly if they are a fixed term or temporary worker. That there aren't any work restrictions in the documents themselves. For example, if the individuals are students, there may be restrictions around the hours that they can work or the time periods. You also need to check there's no tampering and that it does appear to be a genuine document. And if there are discrepancies in the documents themselves, ask for an explanation as to why there are discrepancies. For example, if there are name differences, it may be that somebody has recently got married or divorced, for example, and that's why there is a difference in surnames. There's a reasonably apparent test in terms of what you must know, so you're not expected to be an expert in detecting forgeries. What you do need to do, though, is make sure that you take reasonable steps, and if something is reasonably apparent that there is a genuine document that has been tampered with, for example, or that the explanations given to you don't appear to be rational or reasonable, then you would be expected to ask further questions or perhaps doubt the authenticity of the documents you've been given. There are companies that can assist in relation to checking the validity of documents, and you may well within your organisation have a nominated point of contact who can assist in relation to this. It's always a useful idea to get in touch with your nominated HR contact or somebody who deals with external agents around this issue, just to understand if that's something that's available to you. Step 3, copy the documents. This is an important step that sometimes employers may overlook or not be as stringent upon. In terms of what you need to copy, the copy itself has to be clear, but it can be either in electronic or hard copy format. If you're copying a passport, copy only the relevant pages where it sets out the individual's date of birth, passport number, identity, and then also the relevant pages setting out the nature of their visa, for example, and their right to work. If it's any other document, then you should copy that document in full, and importantly, you should record the date of the check that you've carried out. You have to retain copies for at least 2 years after the employment ends, just in case you do get an inquiry from UKVI. In terms of practical steps, the first most important step is to check before you employ somebody that they do have a right to work. Be wary of individuals who say that they will provide documents to you afterwards, or simply accept on face value that somebody does have a right to work. This is a breach of the rules, and you can find yourself suffering serious consequences. If somebody's given you a list A document, then there isn't any further follow-up that you have to carry out when they're employed. If somebody's given you a list B group 1 document, then you do need to make sure that you follow up on the individual's right to work upon expiry of the permission that you've recorded. And if somebody has given you a list B group 2 document, you do need to follow up again after a 6-month period to make sure that you still have a statutory excuse you can rely upon in the event that somebody no longer has a right to work. Practical steps 2. There is an employer checking service that the Home Office provides, and you are required to use this if somebody can't show you their documents. For example, they've got an outstanding appeal or application with the Home Office. or they've given you an application registration card, which is a List B Group 2 document, or they've given you a certificate of application, again another List B Group 2 document. When you carry out this check, you should receive a positive verification notice. If you don't, then you should seek help in relation to that and further advice. Practical steps 3. There are specific categories of workers to note where there may be restrictions and you need to be more wary when carrying out right to work checks. For example, students do have work restrictions that usually apply. If that's the case, then they may be restricted on the hours they work, but also the time periods within which they can work. EEA nationals, so nationals from the European Economic Area, which is wider than just the EU, do have a right to work, but the employer must still check, so you do need to check that the person is in fact an EEA national. Again, you can't simply take it face value. You may have a situation where non-EEA family members of EEA nationals are being employed. So for example, somebody outside of the non-EEA area may say to you that they do have a right to work as a result of being married to an EEA national. If that's the case, then they do indeed have a right to work in the UK, but again, you do need to check this out. And in those circumstances, it may be that a document other than List A or List B document is acceptable. But again, on this particular point, we would suggest that you seek advice. In dealing with queries, you should have a nominated point of contact. Alternatively, our contact details are included in this slide and we'd be happy to assist if you do have any specific queries around any right to work checks or documents you've been provided with. We hope you found this webinar useful and thank you for your time.